Swayam Prabha. Digital India. Educated India.
Greetings to all the learners. So, in the last session we have studied about regulatory commission. Let us continue to discuss some of the facets of regulatory commission, and also let us understand that the important functions which the regulatory commission discharges. Now, in this session we will try to understand what the power and function of the regulatory commission, the most important power to adjudicate, how it is to be understood, and also what are the opinion of the court on the power of the commission. Now, when you look at the scheme of the law, there are three important functions which are being entrusted upon the regulatory commission. One is the mandatory, second one is the advisory, and third one is the legislative. Now, mandatory and legislative you would find a bit overlapping, but I have placed them separately because of the very fact that I have considered regulation making power as a legislative one. Though we have studied while discussing tariff that tariff fixation is also of legislative character. So, please take note of this when you are reading on tariff, and then when you are reading about the power and function of the regulatory commission at this stage. Now, when you look at the mandatory function, you would find that section 79(1) in case of Central Executive Regulatory Commission and section 86(1) in case of State Executive Regulatory Commission describes the function of the commission. And what are the main functions? Tariff regulation, overseeing interstate transmission of power. In case of State Executive Regulatory Commission, it will be intrastate, issuance of license, adjudication of disputes between the generating stations and the licensees. So, you can find that the function which is given under section 79, it can be classified into two components. One is the decision making, which is about the issuance of the license, which is about the revocation of license, which is about the suspension of license, which you have discussed in detail in the earlier sessions. It is about tariff determination, it is about ensuring that tariff determination through competitive bidding has been done in a fair and transparent manner. So, that is these kind of functions I am categorizing under the decision making heading. And the second one is the adjudication, because commission has been also interested to adjudicate the dispute which may arise on the issue of tariff, which may arise on the issue of issuance of license, which may arise on the issue of interstate transmission. In case of state, it is intrastate transmission. So, what we need to understand that the nature of the function of the commission when it is exercising a function distinct from adjudicatory is different. In adjudication, it is about examining the specific case which has been brought by the individual, whereas tariff regulation, issuance of license, in such kind of situation the commission decides based on general application of rules, what is in consonance with the scheme of the act. And we have also looked into the advisory function in the last session, which is given under section 79 subsection 2 or 86 subsection 2, where the commission advises the government to formulate the electricity and the tariff policy, and it encourages the investment in the sector and also the protection of the consumer and also efficiency and economy in the power sector. So, that is the advisory function of the commission, and we have discussed in detail that this advice has to be given a considerate thought. It must not be seen as only an empty formality. And as I said that section 179 and section 181 confer rule making power on the regulatory commission. Central commission or the state commission has been given power to notify the regulations. Now, notifying the regulation in relation to the licensing, notifying the regulation in terms of grid code, notifying the regulation in terms of open access, notifying the regulation in terms of trading margin, levying and collection of fees, transmission charges on the issue of subsidy and cross subsidy, and standards of performance to be followed by the licensees, and what shall be the procedure for tariff determination. All these regulations can be made. So, please do take note that the regulation making power, which is primarily legislative in nature, is conferred on the commission under section 179. And when I say legislative in character, what we need to understand that the commission need not consider particular cases for framing the regulations. It has to keep in mind the general rule of conduct, that what is to be applied generally in a situation. So, that is what we need to consider when you are making a distinction between legislative function of the commission and the adjudicatory function of the commission. And why I am highlighting on this? Because the procedure would differ. In legislative function, the procedural requirement would be different. There may not be a very strict compliance of principles of natural justice in case of legislative function, but in case of adjudicatory one, perhaps it may be suggested. And also in adjudication, it is about looking into the case which has come before the commission. So, what are the disputes which the commission can adjudicate under section 79 or section 86? It says the dispute must concern the regulation and determination of generation of tariff of the generating stations owned or controlled by the central government, or those having a composite scheme for generation and supply to more than one state, determination of tariff for interstate transmission or regulation of interstate transmission of electricity, and state commission shall have a jurisdiction only for intrastate subject matters. So, 79 1A to D is what is the subject matter which has been given. Now, as I said that adjudication is different from the legislative function. Adjudication is all about what has been done and how the same has to be resolved. Legislative is all about laying down the guidelines for future. Please do acknowledge and appreciate that the regulatory commission is been entrusted with both the tasks, this task to frame regulation and the task to adjudicate, and also to decide under section 79, decide on tariff fixation, decide on licensing. So, when the regulatory bodies are being entrusted with the judicial power, then certain safeguards are to be taken note of, and certain approaches are to be appreciated. One is the regulatory body is entrusted with the judicial power. The functioning of such body is quasi-judicial in nature. So, judicial and quasi-judicial we need to understand by using this terminology, that one is about acting judicially, the other is about acting judiciously. Judicial power is about to act judicially, quasi-judicial is about to act judiciously. So, when the regulatory body is entrusted with the judicial function, what is there is about look at the facts and apply law, what is been said as bipolar centric interest, where parties are there, parties are alleging that their rights are being violated, and the adjudicatory body has a responsibility to look at the relevant law and resolve the dispute accordingly. And in that process, regulatory bodies, they need to take into account the interest of the multiple groups. In fact, this is very prominent aspect for interesting adjudicatory function on the commission and not on the code of law, because court of law would only look at what issue has come and how it is to be resolved. But then regulatory bodies would look into the larger interest of the sector, larger interest of the stakeholders, and thus the procedure, the process which the regulatory body would follow, that is entirely different from what is being followed at the or in the judicial process. So, look at the legislative scheme, look at the provisions which are there in the Electricity Act for the same. In order to strengthen the hand of the regulatory commission to effectively adjudicate a dispute, section 94 empowers the commission to summon and enforce the attendance of a witness, examine any witness under the oath, so that later on there shall be no retraction, or if there is a retraction, it shall be followed up by necessary punitive action, receive evidence on affidavits, review its direction, orders and decisions. So, it can review also its own order. And in order to attach sanctity to the proceedings, the proceeding shall be considered to be a judicial proceeding as it has been defined under section 198 or 228 of the Indian Penal Code. And also it has been suggested that the commission would be a civil court for the purposes of section 345 and 346 of CRPC. This kind of provisions you would find almost in every adjudicatory bodies which has been entrusted to discharge judicial function, which has been entrusted to resolve a list, resolve a dispute. Commission has been also given a power to enter into any premise, seize any document which the commission believe that is related to the inquiry which is ongoing, and commission under section 129 also has a power to comply with the directions, and if non-compliance is there, 146, 142 interest there is necessary authority on the commission to punish for such non-compliance. Now, in this, the court has come up with the interesting, analogy, interesting interpretation. This State of Gujarat versus Utility Users Welfare Association is one of the such landmark judgments which the Supreme Court has given in the year 2018. In this case, an important question was raised that should the commission be allowed to function without having any legal member. Why this question was raised? Because adjudication is one of the essential functions of the commission, and section 79 or 86 clearly spells out the power of the commission, and the composition, when we read, it says that there shall be a member from legal background. Now, in this case, the court clarifies and says that considering the function which the commission is been entrusted with, there shall always be a member from a legal background in the commission. A person of law shall always be there, and the same should not be only a case of fulfilling the formality of appointing a member with a law degree. The court categorically said that the person must be holding a judicial office or is a person possessing professional qualification with substantial experience in the practice of law, or who has the requisite qualification to have been appointed as a judge of the High Court or a district judge. So, the court categorically laid down that the person who shall be considered to be a legal member must be the one who is practicing. Merely possessing a law degree and working somewhere else would not be sufficient for the purpose of the composition of the commission. This judgment makes the functioning of the commission more particular by involving a law person, so that it shall be ensured that necessary procedural aspect is being complied with, judicial principles are being followed, and whimsical or arbitrary decisions are not being taken. That is what appears to be an idea for insisting a person having requisite knowledge in law to be a member of the commission. There is a fallout of this judgment. A question was being raised that whether this judgment would also apply for Central Electricity Regulatory Commission, because this judgment was specifically in relation to State Electricity Regulatory Commission. Petition was filed, matter went to the Supreme Court. Supreme Court has asked the Central Electricity Regulatory Commission to not to continue functioning in the absence of a member from law background. Very recently, the stay was being lifted by the court when court was given this information that the appointment of a law member has already been done in CERC. Then the court has lifted the stay and allowed the other members to proceed with the necessary functioning of the commission. This is another case, DVC versus BRPL, where the court has made the observation that the power to adjudicate is very broad. It does not only talk about the dispute between the licensees and the generating companies, but it also talks about the terms and conditions which are being agreed between the licensees and the generating companies. What are the interpretation, what are the concerns with regard to the implementation of such terms and conditions. So, very wide jurisdiction has been given. That is what the court, the tribunal has said in this case, that even the implementation, application or interpretation of provisions of the agreement, that is power purchase agreement, that also can very well be subjected to adjudicatory jurisdiction of the commission. That is what the court has said in this case. And then you have this landmark judgment again from the Supreme Court of 2010. In 2010, an important question was being raised, that can the commission proceed with mandatory function in the absence of regulation to be made under section 178 of the Act. Now, in this case of PTC versus Central Electricity Regulatory Commission, the court examined the legislative scheme, and the court has said that decision making power entrusted upon the regulatory commission is not subject to the regulation to be made by the commission. It is not necessary that there would be a regulation first under section 178 and then only the commission shall exercise the power entrusted under section 79. Having said so, the Supreme Court has also clarified that if the commission makes the regulation, then makes the regulation under section 178, then the decision making power of the commission must be exercised in conformity with the regulation. So, there are two situations. One is the absence of regulation, second is the presence of regulation. The court says that if there are no regulations made, that does not mean that commission shall not exercise its power under section 79. Tariff regulation, issuance of license, interstate transmission charges, all these functions are to be discharged even if there are no regulations, because nowhere in the scheme of the law it has been suggested that the commission shall first make the regulation and then only power under section 79 is to be invoked. But then if regulation has been made under section 178, such regulation has to be considered, kept in mind by the commission for discharging the power and function provided under section 79 and 86. So, to make a regulation is not a prerequisite, it is not a precondition. Also, the court has highlighted that power to make regulation is much wider than the decision making power of the commission under section 79, and this has to be understood in the context that regulation can be made and fallout of the same could be alteration or modification of the power purchase agreement. So, regulation can very well alter or modify the power purchase agreement. Regulation can very well alter or modify the tariff fixation done under section 61. or 62. So, the court in this case clarified the relationship between section 79 and section 178 and made this very clear that to frame regulation under 178 is a legislative function which is very general, which the Commission shall undertake, but then absence of the same would not disallow the Commission to not to exercise the function entrusted under section 79. So, this is a very important clarification given by the court in 2010 judgment. So, this judgment has clarified an important position on the relationship between regulation making power of the Commission and mandatory function entrusted upon the Commission. So, this position in a way clearly makes a demarcation between two different responsibilities entrusted upon the Commission. Thank you very much.